exceptions to the Forcible Felony statute. Exception 1, the Willfull D. What is willful injury? And that's defined in Iowa Code Section 708.4. This code section makes it a crime for someone to do an act with the intent to cause serious injury in which they either cause bodily injury or serious injury. But always they have to have that intent to cause serious injury. Now for the Willfull D, which is a Class D felony, that is the subsection that is specifically excluded from the Forcible Felony statute. The other one, the Willfull C, the Class C felony, is a forcible felony. If a person is convicted of that, they have to go to prison. There is no possibility for probation. See my previous video if you want more detail about a forcible felony. So the main difference, the only difference between automatic prison and possibility of probation, deferred judgment, and works is the level of injury to the victim. So what's the difference between bodily injury and serious injury? Well, a bodily injury is really any injury at all. It could be a cut, it could be a scrape, it could be a bloody nose. It really doesn't even have to require there to be a physical injury. Pain is enough. Although I've never seen a prosecutor charge it that way, and I think it'd be really risky to just take pain to the jury because, you know, they really want to see at least a bruise or something. Now, a serious injury is something serious. It has to have the risk of losing their life, permanent disfigurement. It has to be the loss of a bodily function. Think someone's jaws wired shut, their ears cut off, something that is permanent or could cause lifelong damage to them. So if you apply that to the Forcible Felony statute, the legislature is essentially saying the amount of success of the defendant in doing what they intend to do, which is serious injury, that person is mandated to prison. Whereas the person who isn't so good at setting out to do the thing they meant to do, serious injury, they can have probation, a deferred judgment, the works. And on one hand, that takes the victim's experience into account. The experience of the victim, the pain and injury that they cause, matters as a result of what the defendant's sentence is. But on the other hand, it's saying that the intent, even though they intended and it was there and they meant to do this horrible thing and they only kind of did this sort of horrible thing, that they shouldn't be punished as seriously. So really the question to you would be, do you agree with that? Do you agree that the actions and the causation is more important, or is the intent to you more important? Do you agree with the Iowa legislature on this statute, or do you think that it should be the same no matter what because of the intent?